again to another program, Issues in the News, where we discuss the important events that would have taken place in our country over the past week or so. And I want to begin by welcoming our viewers who are joining us on television from West Coast Berbice. Good evening. And those of you who are joining us on television from East Berbice, region number 6, good evening and welcome to another program of Issues in the News. Our listeners and followers who are joining us on Freedom Radio, good evening and welcome to another program of Issues in the News. And last but not least, to the tens of thousands of you who are joining us on Facebook Live across Guyana, the Caribbean, North America, Europe, Asia, welcome to another program of Issues in the News. And as usual, I want to begin by asking you to share this program. Press that share button on your computer, on your phone, so that the widest possible audience can join us in tonight's discussion. Press that share button on your phone, on your computer, on your tablet, so that the program can be shared by the widest possible audience. I see a number of you, hundreds of you have already joined. Kavita Totaram, Indal Narain, Takurup Narain, Wazim Naziruddin from Pennsylvania, Dud Prasad from Toronto, Ravi Singh, Frank Badri Narayan from Brampton, Ontario, Anita Hill, Jai Giovanni, Shahab Samad, and so many of you. Welcome once again, and thank you for joining us on tonight's program. Well, most of you by now would know of the High Court judgment handed down by the Honorable Madam Justice Priyasuna Bihari in the libel matter which I filed against Basil Williams in relation to his allegation that I stole law books. I did an interview already and I set out the facts. And I want to thank all of you who have made positive commentaries on that video. It was widely circulated, widely watched, widely shared. And in that missive, in that video, I explained that those charges were filed simply to provide a defense to the libel case, which I had filed before. And that's the libel case that was eventually heard and determined. A few people have asked in the comments section under that interview whether the government has to pay or Basil Williams has to pay. I never sued Basil Williams in his capacity as Attorney General. I sued Basil Williams in his private capacity. Though he was the Attorney General, he libeled me personally. So the damages are recoverable against him personally. It has nothing to do with the office. Of course, in the course of the trial, he attempted to argue that he should have been sued in his official capacity. And we had detailed arguments on that issue. And the judge overruled his contention and ruled that I properly sued him in his personal capacity. So I also want to take this opportunity to thank my lawyers, Manoj Naran, Rajendra Jaigobin, and Darshan Ramdani Casey, who did an outstanding job together in prosecuting that claim. So I hope that that matter is now put to rest, and it is recognized that the transaction out of which that charge arose has now been upheld as a legal transaction by our High Court. As I said, if Basil Williams wishes to appeal, then he is to do so. I will cross-appeal, and I will claim a greater sum in damages, because I believe that the learned judge should have awarded a higher sum in as damages and as appropriate compensation. But we will deal with that whenever it arises. A lot of things going on, and I thought today that I will address in particular some of the matters in my sector. But before I get there, I want to take this opportunity to extend congratulations to the government and people of the United States of America. They are celebrating their 247th independence anniversary. And it's a great occasion. And from this program, I extend our warmest congratulations. At the level of CARICOM, that important regional institution is also celebrating a milestone, its 50th anniversary. I want to take the opportunity as well to offer to CARICOM and to every CARICOM member state our congratulations. CARICOM has a very crucial role to play in the next 50 years in uniting the Caribbean region. There are a lot of new and emerging challenges on almost every front. Among them, rule of law issues, security issues, economic issues, food security issues, internationalism, climate change. These are very crucial issues that the Caribbean will have to unite upon going forward in the next 50 years or so. So that institution will continue to serve the people of the region. An important component of Caribbean integration is the acceptance by more member states of CARICOM of the Caribbean Court of Justice as their final appellate court. That's a very important issue that I hope within the next few years would continue to receive the highest priorities among nation states who have not yet accepted that court as its highest court. It is important, I believe, that the entire region signs on to the Caribbean Court of Justice. I believe that over the past decade and a half or more of its existence has demonstrated that it's a quality court and that it can dispense justice in a fair, impartial manner and can be compared with any other final court anywhere else. I believe that they have established that by their track record in terms of the quality of decisions that they have delivered thus far. And therefore, the time is ripe for the rest of the Caribbean region to accept that court as their final court. Secretary of State Antony Blinken will travel to Guyana as part of his first official trip to the Caribbean on July the 6th. Now, this is a very important office holder in the U.S. government, and it is the second visit by a U.S. Secretary of State after Mike Pompeo visited Guyana in 2020. Now, this is no ordinary achievement. A small country like Guyana receiving visits from two secretaries of state under two different administrations and under two different political parties is indeed a significant accomplishment. It has to demonstrate that Guyana means something. Well, Guyana has assumed importance in the eyes of the U.S. and the rest of the world. Hence, Guyana is seen as a destination to visit. These visits, I don't believe, are ceremonial. They are significant. A top official from Canada's parliamentary secretary to the Minister of Foreign Affairs, is due to visit Guyana from July the 5th to the 7th to discuss energy, food, and business. Now that's another significant visit. And this is in addition to all the other visits from different heads of states and from different governments across the world. When countries such as Canada and the US are sending these high emissaries to one's country, it sends a particular signal that things are on the upward movement in Guyana. So I just thought that I would mention that to observe the significance of these visits. I want to get back to my sector and to speak about some of the issues that we are working on. So we have currently ongoing a project to revise all the laws of Guyana. Revision of laws is the process whereby all the amendments that have been passed have to now be consolidated into the existing laws. And all the new laws have to be inserted into the new laws, and then a fresh set of the laws will be printed, and that will be the most updated version of the laws of Guyana. The last time this exercise was done was in 2012, and we are going to conclude one hopefully before the end of this year, another one hopefully by the end of this year, 10 years after the last law revision exercise was done. The revision exercise will update the laws of Guyana as of December the 31st, 2022. From 2012 to 2022, December 31st, all the amendments that we have passed for laws and all the new laws which we have passed in the Parliament are now going to be consolidated and inserted into the existing laws. Of course, soft and hard copies are going to be done. And then we go to the printers once that consolidation exercise or what is called a revision exercise is completed. There's one company in the Caribbean that offers that service, and it is out of the island of Anguilla, and that is the company that has been retained to do this task. And the task is well on its way. We have received, they're doing it in 2 sets. We have received from them already the notification that they have completed the first installment of the exercise, and they are now working on the second installment of the exercise. We have to then print, and of course we will have soft copies, and it will be posted on the government different websites, including the Ministry of Legal Affairs website, and it would be accessible to all the world. Of course, hard copies in limited numbers are going to be published as well and circulated to the government and state agencies, as well as to private individuals who desire to possess a copy of the laws of Guyana. Another important exercise that we are working on, which hopefully will conclude this year is to update our law reports. Now, all important cases are reported in volumes called law reports. Many countries have that. As viewers are aware, judges or the judiciary act upon precedents. They guide themselves by previous rulings on important issues. And that is hence the need to chronicle these judgments so that they can easily be accessed by judges, lawyers, magistrates, and even members of the public, if they are so inclined. An important part of any justice system is an updated and efficient law reporting system that allows one to easily access existing decisions. In Guyana, we have inherited, or in Guyana, we are fortunate to have had a very good law reporting system dating back to the 18th century, right through to 2007. The last edition of law reports that came out was from 1977 to 2007. And since assuming the office of Attorney General, I commenced working on updating that from 2007 to 2020. So it is a monumental exercise having regard to the number of years that we have to cover to bring us at least up to 2020. And then, of course, after that, I'll do another installment, and hopefully we can do it annually. But these are very, very important, facilities in our legal system. And it is important that we chronicle our court decisions so as to guide future conduct. In Guyana, we have a number of important decisions relating to elections, in relation to the Constitution, in relation to democracy, no confidence motion, appointment of the chairman of GCOM, proprietary interests. All these decisions, we have to ensure that we record them and they become accessible for judges to continue to use and for future generations. So the law reporting system allows that type of record to be kept and to be readily accessible. So that is another project that we are working on. Tomorrow, a special select committee will conclude its work on the single window transaction bill. And after that, the bill will then be taken back to the National Assembly for passage. Now, this singular bill and the concept that it embraces is significant to ending years of bureaucracy that exist in the system. And members of the public must know these things and must understand the importance of these legislation. As you are aware now, to build, you have to get planning permission. And that planning permission will only be granted once a number of other permissions are granted. That process over the years have become a very cumbersome one. It is long, It is tiring, it is frustrating, and one experiences bottlenecks along the way. This single window system allows you to put in all your applications for the various permissions at one single window. And machinery will now be established that will take your various applications and send them to the various agencies. And that machinery will then place the applications at the various agencies to ensure that it is not sitting on anyone's desk for any undue period of time, and will ensure that at each stage of the process, the file is constantly pushed to avoid delay and to avoid the backlog currently plague the system. This will save millions of dollars in time and will remove the horrible administrative and bureaucratic red tapes which plague the system. Take, for example, a man who has to take a loan from the bank to do a particular project. So he goes to the bank, he makes his application, and he gets his loan. The bank is ready to disburse. But he can't build because his permission is not granted. His plan is not approved. He has to run up and down. Then he has to get fire approval and a whole host of other approvals. And at every step of the way, there is tremendous delay and incompetence. That whole road that one has to travel will now collapse into a single handing over all documents at one window. And that window, as I said, will then travel the road and bring back all the permissions to back at that single window to be uplifted at a time that one will be told when one makes the application. Of course, it means that you have to pay all the fees and everything up front. So the bill itself lists the agencies that will become part of this single window, and they include the Central Board of Health, the Ministry of Public Works, River and Sea Defense Board, Guyana Lands and Surveys Commission, the Environmental Protection Agency, Guyana Fire Service, Guyana Civil Aviation Authority, National Trust of Guyana, Guyana Office for Investment, the Land Registry, Deeds Registry, Guyana Water Incorporated, Maritime Administration Department, Guyana Forestry Commission, all the neighborhood democratic councils, and the local authorities, inclusive of municipalities. So depending upon the nature of your task, depending upon the nature of your project, you have to get permission from these agencies, And currently, you have to go to each one to get their individual approval. That is going to change in a fundamental way. And you, the citizen, will be relieved of running from one agency to the other. All you will do is to put your documents in at this single window, and someone at that single window office will tell you, check us back in 4 months. If at any stage of the way there is additional information required by any of the agency, then you will be informed and you will be required to submit that information. So let us say you have an application in and which requires an environmental assessment to be done. So the file has to go to the environmental assessment, environmental protection agency. If at that agency it is recognized that there is something deficient in your file or you need to provide some additional information, then you will be notified and requested to provide that information. and the process continues like that. But you don't have to be running up and down to all the agencies. And that's the beauty of this system. At the Select Committee, I must say that the opposition and the government enjoyed great rapport and agreement on almost all the clauses. And that's why I'm saying that this, normally you don't get the opposition support on anything, but on this matter, they have lent their support, and it's a beautiful concept. If we can get this to work in Guyana, it would save every one of us a lot of time, a lot of energy, and a lot of money. So this bill is one that will revolutionize the way we do business and the way we obtain the various type of permits and permissions once we are constructing. This will change that completely. I don't think that there is any such mechanism yet in the Caribbean. We will be leading the way with this mechanism. This was an initiative of His Excellency the President, and he must be recognized for the type of visionary leadership that he's lent in this regard. We worked with a Canadian consultant on this matter who has had vast experience in Canada and elsewhere on single window machinery. And he has worked with us on this concept, and we are now about to complete the legislative stage. After that, the physical infrastructure will now have to be built. But once we get this right and we get this going, this would transform the manner in which we have to process planning permission and building permits in Guyana. So that's a very significant accomplishment in my respectful view. The work continues on the AML CFT front. Guyana continues to prepare for an on-site evaluation and examination to be conducted by the Caribbean Financial Action Task Force of Guyana's financial sector, scheduled to take place in September of this year. We have to implement a number of administrative decisions and measures, as well as strengthen many aspects of our legislative architecture. And we are working on both fronts. In terms of the legislation, we have prepared a real estate bill. That bill is now ready to be taken to Parliament after a cabinet subcommittee considers it. The real estate industry has been flagged as one of the areas that we need to regulate because of the volume of property sale and rental transactions taking place in Guyana. This industry has been identified as a risk if it is not properly regulated. So we commenced work on a real estate agents and brokers bill. We concluded several rounds of consultation with many important stakeholders, in particular the real estate agents themselves, because they are the main subject or main subjects of the regulatory framework that the bill establishes. And the bill has been out in the public domain, but most importantly, we have concluded the work after many rounds of consultation with the sector itself The bill is a consensual one, meaning that we have received the fullest support from every single real estate agent with whom we have interacted. And in Guyana, apparently there are two major real estate groups. We met with both of them and received their inputs and brought both of them to the table and got consensual positions from them in relation to every single provision of the bill. Then we have also a Guyana Compliance Commission Bill 2023. Now, in our AML-CFT structure, it has been recognized that there are agencies that have no regulator or supervisor to regulate them. We have been forced to use agencies that are not really regulator or supervisor to perform these functions. And it has not been very effective. The system remains weak. So GRA, for example, has been tasked with a number of administrative functions over agencies that GRA does not really regulate, simply because we did not have that regulatory framework in place. So take, for example, the auto sale industry. The GRA issues certificates of registration. That doesn't necessarily mean that the GRA can regulate that industry or can supervise that industry. GRA's function is one of taxation and revenue collection. It doesn't have a supervisory role over the taxpayer other than what the individual statutes confer upon it. So, and that is a position that many countries in the Caribbean in particular has had to face. And they have done what we are going to do. Set up one commission called a compliance commission. And wherever one cannot find a proper regulator or a proper supervisor for any given area of economic and financial activity, this compliance commission will act as the regulator and will act as the supervisor. And that will make us compliant fully with international standards set out by CFATF and the Financial Action Task Force. And we are promulgating that bill to bring us into compliance so that we can be faulted for not having such an apparatus in our AML-CFT framework. We are also working on anti-money laundering, countering the financing of terrorism amendment bill. Those of you who have been listening to me over the past years, you would recognize that we have constantly updated this aspect of our laws to keep up with recommendations that emanate from the Financial Action Task Force and the Caribbean Financial Action Task Force. So this bill is always under review. We have completed the last set of review, and that will also be taken to our Parliament because we have to complete these bills before the on-site assessment begins by September. In these sets of amendments, we have strengthened tremendously our capabilities legislatively to forfeit assets and proceeds of crime. It is recognized now worldwide that one of the most effective ways of dealing with the criminal is to hit him in the pocket or hit them financially. And the way to do that is not only to convict and sentence, but to go after the proceeds of the crime, go after the assets acquired from the criminal conduct. And our law was not strong as it should be in that regard. We have received international help from the regional security services of the Caribbean. We have received help from the national state courts of the United States, and we have looked at other legislation in the region, and we have a slew of amendments that we are going to implement now that will allow for forfeiture of assets to take place and for proceeds of crime to be adequately provided for in the law so that we can enforce this aspect of crime fighting. As I said, internationally it has been very successful. If you're able to dismantle the criminal empire, then you dismantle the criminal conduct. And that is where our laws are now going. And that is the type of enforcement that we will have to focus on in the next few years. So those amendments are ready, and they will be taken to the National Assembly as well. You know, we put out there the data protection bill. We have a lot of noise from a lot of people when we first spoke about the resident card, for example. And one of the issues that was raised in the public domain, critical of the government, was that we did not have data protection legislation, and that the information that will be stored on that card can fall into the wrong hands or can be unauthorizedly disseminated. And that is true. But those criticisms were premature because we were working on a protection bill. So that data protection bill, we have completed work on it, and we put it out there for public input and for recommendations from the very people who were clamoring for such a bill. I am disappointed to say that we didn't receive much input from the public, and the bill now is ready for Parliament. It is another significant piece of legislation in which persons' data will now be collected, stored, and used for specified purposes. For example, medical information. You would have heard that Northwell, one of the largest medical healthcare provider in New York, is now in Guyana and has been for the past week or so, performing some 60 or more medical operations at the Georgetown Hospital. We have arrangements with medical care provider like Johns Hopkins and other important international medical care providers. And we have been requested to ensure that we have the type of legislation that would allow for the access and storage of persons' medical record. We didn't have that legislation. This data protection bill now provides us with that legislative infrastructure that will allow us now to store persons' medical record and maintain the requisite confidentiality so that your medical records can now be accessed by your doctors whenever it is necessary. These are transformative changes that are taking place in Guyana. And All of that, all of these legislative changes are intended to prepare our legal landscape for the type of developmental agenda that we are pursuing. You can't have development without the legislative framework in place to accommodate and facilitate these developments. And that is what we are doing. I heard a lot of things being said about the criminal justice system, and yes, we have problems in the criminal justice system, but the government is working every single day to improve the criminal justice system. I spoke last week about sentencing guidelines. That a draft has been prepared and we are waiting for an input from the judiciary. The abolition of preliminary inquiries bill has been completed. That is out there with the Guyana Bar Association and other important stakeholders for their input. That singular bill will abolish preliminary inquiry country. So you wouldn't have this backlog and you wouldn't have persons remaining for a protracted period on remand awaiting their trial. That entire process called preliminary inquiries will go and be substituted with a paper committal system where the magistrate will simply read all the statements and determine whether this person should be tried, and then make a decision to commit the person to the High Court for trial. No hearing in the magistrate court anymore. That will bring a tremendous ease to the backlog and to the number of cases at the level of magistracy. Of course, correspondingly, it will shift the workload over to the High Court. So we have to build the capabilities in the High Court because the intention is not to shift the work from one court to another, but ensure that these cases are heard at whatever forum and heard speed in compliance with the constitutional guarantee of a fair trial within reasonable time. It means more judges have to be appointed. It means more staff have to be appointed. It means more resources have to be made available to ensure that the system works. The government is committed to resourcing this process. So that's another important piece of legislation. Last week I spoke at length about the plea bargaining bill, which again is out there for public consultation. That will be concluded shortly and that will be implemented. That bill or that law, once the bill becomes law, will allow the defense and the prosecutor, even before the institution of a charge and after the institution of a charge, to sit and try to work out a position. There are going to be safeguards in the bill to ensure that criminal matters are not settled and guilty persons who have committed grave criminal acts are allowed to walk free through some settlement. That is not going to be the position. It is going to ensure, the bill is going to ensure that at the end of the day, there is no miscarriage of justice. It allows, for example, if a man wishes to plead guilty, the defense and the prosecutor enter into the plea agreement and present it to the court. And there is no need to empanel a jury, there is no need to waste days in getting file ready, etc., etc. All of that can be done in a few minutes, and once the agreement is presented to the court, that's the end of the matter. The court just pronounces upon the sentence. So the plea bargaining legislation has worked throughout the Commonwealth, and it was mentioned recently by Justice Witt of the Caribbean Court of Justice when he was in Guyana last week. So we are moving in that direction well. We are also working on a new, we have spoken at length about the arbitration bill. The arbitration bill is receiving receiving inputs from a law firm in Washington, D.C. Already had a British law firm examine the bill and they made comments. We are now receiving assistance and guidance from a Washington-based law firm. So not only would our bill be compliant with the British system, but it will also accommodate the American-style legal system. The reason for that is that when the bill is promulgated, it is expected to be one of the, it is expected to be the best in the Caribbean. Let me put it that way. We begun, first of all, it's a Caribbean model legislation. So it was produced for the CARICOM region, but we have ensured that it received input from international law firms, both in the American legal system and the British legal system. And that will give it the international flavor which we want to be reflected in the legislation. So that when we say publicly, or when we say to a company that we have the best infrastructure for arbitration, we would have a bill or a law to support that assertion. We may not have the best arbitrators available, but we can bring them in. The parties can determine that they will choose arbitrators from wherever. But when those arbitrators come to Guyana, they are coming to a jurisdiction that has the most modern arbitration legislation in place. That is what is intended to be achieved, so that commercial arbitration will begin and be concluded in Guyana. The policy intent of this legislation is to ensure, as far as possible, that companies who want to do business in Guyana, who want to invest in Guyana, don't need, if dispute arises, to take their dispute to Paris, Brussels, to New York, to Washington for resolution. They can do it right here. As I said, we are making it attractive enough for companies who offer arbitration services internationally can come and set up an arbitration office or a center here. That is part of the intent of the legislation, if we can do it locally. So big firms such as Arnold and Porter and whatever the other big firms are in Europe, they can come here themselves and set up the arbitration and arbitration facilities, because they have the requisite legislation in place to accomplish that objective. That again is going to ensure that Guyana becomes an attractive destination, not only in the Caribbean, but also in South and Central America, in respect of arbitration. And that is the ultimate objective. And that is why we're taking such great time and energy in this bill. When it finishes, it must be a model that other countries can and would like to use. We are also The Petroleum Activities Bill is out there as well, and it is going through a period of consultation. And while that consultation is taking place, we are also internally continuing to work on that bill. I see there is public commentary in some sections of the press. That's good. That's good. That's the type of, you know, public engagement that we encourage. But we hope that those who are commenting in the newspapers would ensure that they use the forum which we have established to send comments so that it can properly be examined and be part of the consultative engagement in which we are now, which we have activated, because we really would like the input of those who feel that they can make a constructive contribution. Bill was drafted by overseas again, and at the Attorney General Chamber and at the Ministry of Legal Affairs, we have begun already to examine the bill clause by clause to ensure that there is internal compliance and harmony with the other laws of Guyana, while at the same time it meets our drafting instructions and it meets our policy imperatives for the sector. I see a lot of people are confusing this bill with other matters. This is a bill, this doesn't deal with things like what are going to be the terms of the PSA. I see people talking about that. The bill, they're asking us to include in the bill, or they're criticizing the bill because it doesn't have certain things in it. But those are not things for the bill. There are PSAs, which is the profit sharing agreement, that will be between the government, the investor, the oil companies, or the licensees. There's a contract. The bill is something else. The agreements and the terms and conditions of those investments, those have to be the subject of the agreement between the investor and the government. Those are not matters for law. Other matters have to be stated in the law. And I see lawyers are making that fundamental error. So I just want, these are technical matters. And you don't want to, you have to be careful with how you say these things, because you don't want persons to misinterpret what you are saying and come to the conclusion that you're insulting anybody or you're arrogant. These are technical matters. They can't be, one must have a certain degree of technical expertise before they can comment upon these things. Unfortunately, in Guyana, there is this tendency that every Tom, Dick, and Harry Lal wants to talk on things that are way outside of their depth. And that is why you have a lot of unnecessary criticism and controversies erupting. You never hear me speak about cardiovascular surgery, because that's not an area that I know anything about. But a lot of people who know nothing about law, and in particular complex areas of the law, they copiously discuss and write about it. And because of the lack of expertise, they have a convoluted and controversial view and largely inaccurate view of these technical matters. But I suppose one cannot stop people from expressing their views, but I just ask that, we be wary of these things and recognize that technical matters require technical people to address them. And I don't want to talk down to anybody, but when one speaks and one writes, one must recognize these things. These are realities. I would not write and talk about any complex accounting matter And you know, these are simple things that if you observe them and you go to the right person, that's why every day I advise people, they come to the ministry for legal help, and they try to advise themselves, they try to act by themselves in legal matters. And I tell them all the time, I said, if you have your car break down, if your car breaks down, you have to go to a mechanic. If you're not feeling well, you must go to a doctor because you have a medical problem. If you have a mechanical problem, you go to a mechanic. If you have a legal problem, you go to a lawyer. You don't need to do it yourself. If we follow those simple rules, we wouldn't get into half problems that we get into every day. Anyhow, my operator is signaling to me that we have approached program time. I want to thank you very much for spending the past hour with me, the last hour with me. I think we have covered a lot of depth, a lot of ground. I have been able to give you an update on many of the pieces of legislation that we are working on, as well as I have addressed some important issues. Thank you very much, and please enjoy the rest of the week. Join me next week as we continue our discourse. Thank you, and good evening.